Welcome to this VACo webinar on understanding New Virginia law on housing discrimination, what counties need to know. This webinar is developed by the Virginia Association of Counties in partnership with the Office of the Virginia Attorney General. I'm Joe Lurch, VACo Director of Local Government Policy and your host today. Joining me is Helen Hardiman, Assistant Attorney General and Policy Advisor in the Office of Civil Rights, where she investigates and litigates claims of discriminations against Virginians. Helen advises the Virginia Real Estate Board and Virginia Fair Housing Board as members of those bodies determine whether housing discrimination has occurred in individual cases. She also provides the Attorney General, advises the Attorney General on civil rights issues and legislation. Prior to starting state government work, Helen founded Hardiman Law PLLC to prevent and end housing discrimination in Virginia. In less than 2 years of practice, Helen assisted over 100 families in securing and maintaining fair housing, including obtaining monetary relief for survivors of race, gender, disability, and family status discrimination, avoiding evictions, reinstatement of housing subsidies, and granting of reasonable accommodations. For 8 years, Helen held leadership positions at Housing Opportunities Made Equal of Virginia, also known as HOME, a private nonprofit civil rights organization where she directed HOME's statewide fair housing outreach, policy, and enforcement programs. While at HOME, Helen filed and settled 17 fair housing cases across Virginia, naming HOME, including against property managers, developers, newspapers, and a retirement home, resulting in relief exceeding $6.4 million. Helen is a licensed Virginia attorney who holds a JD from the University of Virginia School of Law and Masters of Social Work with a concentration in administration, planning, and policy from Virginia Commonwealth University. Hi, Helen, and thank you for joining us. We feel that given your resume and experience that you're going to provide us with some great information. So the goal of today's webinar is to provide Virginia counties with an understanding of changes to housing discrimination law that impact local implementation of Virginia land use decisions and ordinances. Specifically, what we're talking about is House Bill 2046 from the past legislative session, which becomes effective July 1st, 2021, and applies a new standard for local governments to comply in avoiding housing discrimination. Helen will give us a brief presentation, including an introduction to the topic on the new standard and best practices counties can employ, not only to comply with the law, but incorporate strategies for addressing housing needs within their communities. I'll ask questions along the way and at the end of the presentation. So let's get started. Helen?
Thanks, Joe. I'm really excited to be here. I've known you for years, and I'm really pleased that VACo has invited me to do this. Dean Lynch is a proud member of the Virginia Fair Housing Board, and so I really appreciate VACo's commitment to fair housing. And I'm excited to provide some information about this new law, which is relatively innovative across the country, but really important in furthering fair housing and preventing housing discrimination by localities. So I do need to give a quick disclaimer that nothing I say today is legal advice. These zoning and permitting cases in particular are very complicated. There's a lot of different actors. There's multi-layers of decisions. And so these are fact by fact or case by case, very fact intensive analyses that happen in these cases. So I'm not going to be able to opine today or provide any legal advice, but I'm excited to talk about this new law. So today I want to set a little bit of context by saying Happy Fair Housing Month. April is Fair Housing Month, and that's because the Federal Fair Housing Act actually passed in April of 1968. And as we talk about housing discrimination by localities, by counties, it's helpful to think about what actually animated the Federal Fair Housing Act in the 60s. And here are a couple of quotes by the patron of the Federal Fair Housing Act, Senator Mondale, who just actually passed away last week. And this is him talking about housing discrimination by localities in 1968. So he talks about the Federal Fair Housing Act being intended to undo the effects of the past state and federal unconstitutional discriminatory actions. So you can see in the 60s, this is happening, and legislators are aware that, unfortunately, local governments, had a role to play in that. He says, Black people, and he used a different word that I will not, just sort of old-timey, not a slur. Yeah. Black people who live in slum ghettos, however, have been unable to move to suburban communities and other exclusively white areas. In part, this inability stems from a refusal by suburbs and other communities to accept low-income housing, which is an important factor contributing to the exclusion of Black people from such areas. So you see the whole genesis of the Fair Housing Act was about allowing affordable housing to be built and accessed by everyone in all communities. So I think that's an important context to keep in mind when we're, talking about black letter law, which is sometimes less sexy. And since the early 70s, courts have recognized this principle as well, that local governments, unfortunately, have been part of the problem in creating and reinforcing segregation in the country. And so from very early on, after the passage of the Federal Act, courts have held localities liable for this kind of discrimination. Now, that said, it has always been unlawful under the state and federal Fair Housing Acts for localities to discriminate based on the list of protected classes. And that's because the language is really broad. So this is a quote from the Virginia Fair Housing Law. It's an unlawful discriminatory housing practice for any person to basically otherwise make unavailable housing because of someone's protected class. And the list of protected classes, it's growing in Virginia, but that's race, color, religion, national origin, disability, family status. Now we have sexual orientation, gender identity, veteran status, source of funds. It's become a mouthful. And person here is also really broad. And you see, I've bolded governmental entities. So it's unlawful for any person, including a governmental entity, to make housing unavailable because of someone's protected class. That's longstanding law. And so a lot of these cases against localities that we've seen across the country allege discrimination based on race or national origin, where an affordable housing developer wants to come into a community and needs rezoning or needs permitting in order to be able to build, let's say, for example, a low-income housing tax credit financed housing that's going to serve low to moderate income people. Neighbors and others will come out and say, we don't want affordable housing in our community. If you track the case law, until this new law goes into effect, you really have to prove in order for that, if the locality then denies the housing or denies the rezoning, in order to violate these provisions of the law, that developer would have to show that the locality was making that decision because of the race or the national origin or of the insert protected class of the people who would likely live in that community. And as we'll see in some of the cases, coded language and certain phrases and references to certain things have been held by courts to amount to racial discrimination and national origin discrimination and disability discrimination. So you don't have to, the locality doesn't have to say, we are turning down this affordable housing because Black people are going to live there to be liable. And some of the coded language that you hear that courts have found to be discriminatory are things like, we don't want those people, folks that live in affordable housing are, criminals and a bad element, and they're going to, lower property values. In order to prove that that's discriminatory, developers and plaintiffs in these cases have had to show that those meant race, color, religion, national origin. They had to tie that back to a protected class. And so what we saw happening in a couple of states around the country is legislators wanted to skip that step of having to attach the intent to a protected class and just go ahead and say outright, you can't say no because it's affordable housing, which is just more of a straightforward way of saying, don't use stereotypes about who's going to live in affordable housing to deny, a developer's request. So I did as much research as I could about these types of laws in other states and found the first one I could find was actually in California. That was in 1984. And you'll see in their fair housing law, they prohibit discrimination specifically in land use decisions or in the permitting of development. So you see they're honing in already on sort of local decision making. They prohibit discrimination in those contexts against the method of financing and the intended occupancy of the development by lower income folks. Florida passed a similar law in 2000, And that was part of a big neighborhood revitalization bill. It passed unanimously. And part of that bill was in the Florida's fair housing law. It said you can't discriminate, localities can't discriminate against the source of financing of a development. Again, for example, low income housing tax credit is sort of the standard affordable, financing tool. And then in 2009, North Carolina modified it a little bit, and this is the language that the Virginia law is based on. And North Carolina said, counties can't discriminate against a proposed housing development because it's going to contain affordable housing units for families or individuals at 80% or below of area median income. So then you really start to see some bright lines drawn about who's covered. So we actually got wind. I was working at Housing Opportunities Made Equal at the time, and we got wind of this North Carolina law and introduced it into the 2010 General Assembly session here in Virginia. It was then Delegate McClellan. She introduced a bill that looked just like this North Carolina bill. That did not pass. The Housing Commission took it up, and it came back again in 2011, endorsed by the Virginia Housing Commission. That was Delegate Dance and Senator Locke. It failed in committee, and then it kind of went away for a while. And then in 2019, Delegate Bourne resurrected the bill and had a hard time in 2019, got closer in 2020, and finally, as Joe said, in the 2021 session, it did pass and will become law July 1 of this year. So I know this is a wordy slide, and I apologize, but this is the language of the law that we're here to talk about today. And I've bolded what I think are the important parts. It's unlawful, and this is in the fair housing law, and we'll talk about the process and the remedies under that law a little bit later. It's unlawful for any political jurisdiction or its employees or appointed commissions. So that's who can be liable for discrimination under this section. That to me reads pretty broad, and y'all know who those people are and who those groups are better than I do, but that seems broad to me. To discriminate in the application of local land use ordinances or guidelines or permitting of housing developments. So we've got the who kind of in the first part of that sentence, and then in what context discrimination might have. And then it says counties can't discriminate in these contexts in these three ways. And it lays out three separate violations of the fair housing law. The first one is the standard list of protected classes. And again, that was already the law. So that's just repeated here again, just reinforcing, hey, counties, you can't discriminate based on race, etc. The second bullet point there was the meat of the bill and what had been introduced since 2010 in Virginia. And you'll see that's just like the North Carolina law. You can't discriminate because the proposal is going to be affordable housing, defined at 80% of AMI or lower. And then the third clause was actually included at the request of some homebuilder stakeholders to say another way in which they claim they saw localities discriminating in ways that would block affordable housing is by requiring any new housing that was going to be built. In order to approve that housing, localities were allegedly requiring that they be for sale units instead of for rent units. And so that was a clause that was added just before session, but that is equally as illegal as discriminating based on affordable housing, like you see in the second clause, or on any protected classes as you see in the first.
Hey, Helen, before moving on from this slide, can you explain the 80% AMI and why that was chosen maybe by North Carolina, or is it kind of an industry standard that's really a class that needs some protection?
That's a really good question. We didn't have a lot of discussions when this bill first came up about where to draw that line. I think 80% AMI is sort of an industry standard of folks that are especially housing cost burden and need new housing opportunities. I mean, LIHTC properties serve people making even lower than that. But and a lot of folks will want to go up to 100% AMI in various projects. But I don't know why 80% is a magic number. That's a really good question.
Well, and maybe just a follow-up question. It says the area where the housing development is located. Does that mean the community, like the county, or does it mean, say, the region? Because I can imagine 80% AMI in Northern Virginia is going to mean something very different from, say, 80% AMI in Southwest Virginia.
Yeah, you're exactly right. And that leaves some ambiguity for lawyers to argue about later, doesn't it?
Yeah.
I do know after talking with my North Carolina counterpart who enforces this North Carolina law that North Carolina uses the MSA to
Mhm.
calculate that 80%. I think that's definitely a fair place to start. That might be something we can address in regulations.
Mhm.
But that would be my first instinct, but it's not defined in the statute.
Thanks.
Good question. So here's the black letter law. What does this look like in practice? So I put together a list of behavior, conduct, actions that may violate this new section of the law. So what about an inspector deprioritizing processing building permit requests for a female developer? That's employee of a local government in the permitting of development discriminating based on gender. What about imposing more expensive infrastructure requirements on a developer because they're from Saudi Arabia? You see how that, again, you have a local government actor, you have a sort of permitting, zoning, local government housing decision context, and then you have the protected class of national origin here. Now, because of is an important word there. That's doing a lot of work. And we can talk a little bit later about how a plaintiff has to prove that they were discriminated against in this way. But I think if that developer could prove that that was happening because of his national origin, he would have a pretty good fair housing case. Declining a rezoning request because the housing proposal will, in part include something religious affiliated. That would be discrimination based on religion. Refusing a special use permit to a group home for folks with disabilities because the neighbors are worried that residents will cause trouble. And this unfortunately happens, and this is discrimination based on disability. This could also, depending on how the facts set up, be a refusal to grant a reasonable accommodation. But my goal on this one is to show how neighbors can feel however they want, and I am glad that they have rights to do that. But the minute a locality, right, a government actor ratifies stereotypes about members of a protected class and the housing is actually blocked, that's when it becomes a real problem from a fair housing perspective. This is the one that I think probably was the impetus for this bill. A board of supervisors votes down a rezoning request for proposed LIHTC apartments because folks with low to moderate incomes were going to be living, right, qualified to live in that development. Or we saw that the clause 3, the planning commissioner tells the developer she'll support a new development only if it's for sale housing. You see how that's discriminating based on the tenure, right, whether it's for sale or for rent housing. So those are some of the examples that I came up with. I haven't seen all of these in real life, just a few. I mean,
Mhm.
Joe, can I pass the mic back to you? Are there any instances that you see that might violate this new law?
I think I can't think of instances, but I think process is really important. And kind of that last bullet makes me think of that. As being a former planning commissioner, I think how you communicate with developers and applicants and staff is really important. Especially when things, get on the record. I do have a question in terms of the LIHTC, the low income housing tax credit. Virginia, as I understand it, is now going to incorporate their own version of that upon the federal. So I think that adds another dimension to that. I don't know if you wanted to address that, how Virginia seems to be at the state level really providing another incentive, and how that kind of boils down to the local level.
Yeah, I mean, LIHTC, the federal LIHTC is the biggest engine for affordable housing in the country by far.
Mm-hmm.
It's successful at getting a lot of units built for a lot of folks. And I think it's fantastic that we're layering on a state incentive. And I think that shows that the leaders in the Commonwealth have really finally understood that we have an affordable housing crisis in the country, and it creates all of these other problems, or in Virginia, it creates all these other problems. And they really want to invest the resources to be able to build more affordable housing units and preserve more affordable housing units. And LIHTC is a really great way to do that because of its, decades success at the federal level. But if you have federal and state and hopefully local dollars going to address this affordable housing problem, everyone needs to be on board about getting these units out of the ground, right? And when you have discrimination or you have other barriers to making that happen, it can really thwart the whole purpose of the LIHTC program. So I think this bill is especially timely in conjunction with the forthcoming state LIHTC program, and hopefully, counties can use this powerful new portion of the Virginia Fair Housing Law to help facilitate the creation of affordable housing in their jurisdictions.
As a follow-up question, does LIHTC, both the federal and the state program, have an AMI minimum, or is that?
Yeah, it depends on the project. I'm pretty sure, I'm not a housing finance person, but I'm pretty sure depending on the application, you have to serve folks earning 60% of AMI or below, and then there's some developments where you can actually serve 50% of AMI and below, but
Okay,
it's
so
less than 80.
Yeah, so it fits within the construct.
Yeah, absolutely. I know the Affordable Housing Trust Fund dollars that go to affordable housing projects often have similar lines drawn at AMI. 80 is usually the highest I see programs funding. I mean, your folks will know better about CDBG and home dollars and those AMI cutoffs for those local dollars. But LIHTC, I think, is 60 and 50 AMI and below. So say one of these things happens and the person who got denied, the developer who got denied, feels like they've been discriminated against. How do they go about proving it? And this is really important to me as someone who has to enforce the fair housing law, kind of what standards I'm looking at and how I'm analyzing the cases. And there's three main ways to prove a housing case. The first two are where the discrimination is allegedly intentional, right? So a county said, we are going to deny this LIHTC proposal because we don't want low income people living here, right? And if they said that on the record, to your point, Joe, or in text messages or directly somewhere, that's an example of direct evidence. And that's my favorite type of evidence, right? Because it's easy to get in and it's easy to prove. But that is rarely available in fair housing cases. And so we end up relying significantly on this prima facie case framework and circumstantial evidence. And so if that developer can show these four things, that basically gives rise to an inference that the decision by the county was discriminatory. It was based on the affordability of the housing in question. And you can see these are going to be pretty easy to figure out, right? Who was going to live there? Did they apply for, rezone? Were they qualified to receive it? That's a bit of a gray area. Did the county reject their application? And did the county approve similar applications for market rate developments? And you can see how if you have those four things, even if you don't have direct evidence of discrimination, it's kind of like there's enough smoke to look further to see if there's fire, right? It's an inference of discrimination. Now, that doesn't mean they win. Obviously, the county or whoever's being accused of discriminating then gets their chance to defend their action. And that's where, again, Joe, the record becomes really important. And that's where the county comes in and says, it's not because of the affordability. It's not because of any protected class. It's because of these legitimate, non-discriminatory reasons.
This is interesting. You're putting on my planner's hat. So we're talking about legislative approval at the elected level, local elected level, because if it's an administrative, permit, whether it's a plat or a subdivision that even goes to the planning commission, you're really just meeting all the standards, and it's not a discretion to approve or disapprove. or disapprove. So I can see this really rising quickly to the, the local elected officials spot. On that last point, the locality approves similar applications for market rate developments. I guess that would, in thinking about it, say it's a special use or rezoning, it would really depend, I guess, on how the comprehensive plan plays in for that area. So I guess that would be a factor that might play into that.
Yeah, I mean, the comp plan plays heavily in all of these cases. And you're right about the level, the elected level is where these cases typically play out. We're going to talk about some actual cases later, and you see that the cases are against localities based on decisions by their electeds. And oftentimes you'll have staff recommend the rezone, right? Recommend the proposal because it does meet the criteria that you're talking about. The planning commission, seal of approval there. Then it gets to the board of supervisors, and that's really when the opposition becomes really overwhelming, and there's political pressure. And so that fourth element there, to your second point, it's not just they approve similar applications than for market rate developments. I mean, we have to still have apples to apples, right? And that's why these cases are so complicated, because the electeds aren't making decisions based on one variable, right? They're making decisions based on a myriad of things. So you really have to, and we'll see in a different case, drill down and really get to the bottom of why the county made the decision. Was it for a legitimate reason, or was it for a discriminatory reason? And sometimes that's hard to root out. And you'll see these cases go for very many years as we try to get to the bottom of that. So another way to prove these cases, though, is even if you have the best intent, you can still be liable for housing discrimination. And this is the theory of liability known as disparate impact. But it's important because I know a lot of us don't feel like we're discriminating, or don't feel like we have biases, or don't feel like we're bending to the will of, a constituency that we don't agree with. But it doesn't matter if you do it on purpose. If you block a housing opportunity and it disproportionately affects a protected class, so we're talking about race, color, religion, but now we're also talking about, in this context, 80% below of AMI, or you block a housing proposal and that perpetuates segregation in your locality based on race, color, et cetera, or now also affordable housing, and it's not necessary to achieve a substantial, legitimate, non-discriminatory interest, you can't justify it. Or if you can justify it, but there's a less discriminatory alternative, you're liable for housing discrimination. And I know that seems scary, because even again, if you have no heart to do any harm to protected class or affordable housing, you really need to take special care to make sure that the decisions are based in substantial, legitimate, non-discriminatory interests. And that's straight out of the HUD rule on disparate impact. So again, Joe, decisions need to be made carefully, and the record created with an eye to some of these theories of liability.
While we're on this, I mean, it goes back to my previous question in talking about the comp plan. So there is a part of code that when you're preparing your comprehensive plan, whether you're updating it or revamping it, you need to survey and study the need for affordable housing in both the locality and the planning district with which it's considered in. So maybe this is an opportunity. I wonder if you see this as a part of the opportunity to maybe address this question. In other words, through your comp plan, do you know where the needs are and where these communities are situated? And could you maybe avoid this unintentional discrimination through that route?
Yeah, I think you're exactly right. And I'm not a planner, so Joe will have better advice on this than I will. But yeah, I think that's step one, is doing a serious needs assessment of housing needs assessment in your community. And I don't know every county in Virginia, but I can imagine most, if not all, need more affordable housing, right? We just have an incredible shortage of it. And so a county should figure out what their residents need, or potential residents need, where that housing should go, so that residents of those communities have access to opportunity, have access to transit and jobs, and all of the community of opportunity indicators that we hear about. Listen to the folks who are actually going to live there, and then as you're finalizing the comp plan, make sure that it's enough housing for folks, and make a commitment to really putting the resources behind making that happen, and committing to overcoming any opposition that will stand in the way of that happening. Really good point. So let's talk about some cases. And I don't mean these to be scary. I mean them to be examples, right? Instructive examples. And I think I mentioned I talked to my counterpart in North Carolina and a legal aid attorney down there who's familiar with a couple of these cases. So I really want to talk about the 3.5, 4 North Carolina cases, and then the New York and Arizona cases that I have on the slide. These are cases by affordable housing developers against municipalities, localities, but they're not based on discrimination based on affordable housing. They allege discrimination based on other protected classes like race, color, religion, but you'll see similar sets of facts. So Pinehurst Village, there was a 2013 denial of a rezoning request for a developer to be able to build 56 units of affordable senior housing. And the community where that was going to be located was 90% white at the time. And based on some community opposition and examples of phrases that were used in that opposition, legal aid filed an administrative complaint with the North Carolina Human Relations Commission. So that would be like the Virginia Fair Housing Office here in Virginia, alleging discrimination based on race and affordability, that 80% AMI or below, against the village. They named the village and the village council. The developer, or legal aid, in addition to representing the developer, actually got a couple of potential tenants of the would-be senior housing to actually join the complaint, which I think is interesting, because they alleged they were injured by the discrimination because if the housing was allowed to be built, they would have taken advantage of it. So that case actually settled relatively quickly in the course of litigation with the village agreeing to support the development, to grant the rezoning, support the development, and they paid $90,000 to the complainants in that case. So that didn't go to court, that just went to the administrative agency. In Clemens, North Carolina, village of Clemens, this is a 2015 rezoning denial, 80 apartment units financed by LIHTC in a community that was 80% white. Again, you have a developer and several potential tenants finding legal aid, filing against the village and the council, claiming discrimination based on affordability, race, and here they also allege national origin. I think there were some statistics surrounding this area that Latino folks were going to qualify to be there and were otherwise not able to really access housing in that community. The village defended the case, saying that the proposal had inadequate access to streets, both for traffic purposes and emergency vehicle access. So you see, again, the county's the locality has full right to defend itself and provide the real reason that it made that decision, to show that it wasn't discriminatory. It was these other reasons why we denied it. So this case was investigated by the North Carolina Human Relations Commission, and they found at the conclusion and issued a determination to this effect that there were reasonable grounds to believe discrimination occurred in this case. And the reason they found that is because in analyzing the village's defense, they basically refuted it, okay? Because they found evidence that the developer had agreed to the changes to the streets that the locality asked for. And they found that the village had approved market rate developments with similar access issues. So you see, once you can get apples to apples, everything's pretty similar except for that key variable, right? The protected class. You can infer that discrimination happened because basically the defense it wasn't shown to be true. It was pretext for discrimination, is the fair housing term of art. So that's settled in 2019. So that was 4 years of investigation for $150,000. Now I have the times two there because, and I don't know a lot of details about this. I could only really find a couple of news stories, but the same developer then sued the same locality less than a year later in 2020 for, it was a different project, but it was a very similar setup. It was going to be, I think, like 70 some units of affordable housing. And so, and now they took that case to court. So remains to be seen how that one will turn out.
And maybe I missed this, but in the first one, was the development finally approved, or is it just settled for a monetary award?
I mean, the settlement required them to support and approve the development, but I did not circle back and confirm that happened. But my assumption is that yes, they made good on the agreement. So let's talk about a case where discrimination was not found, and that's in the city of Wilson in North Carolina. This was a 2015 rezoning denial for 192 multifamily units in a community that is 50% Black. So you see how the demographics are very different here. In the first two, it was predominantly white areas. This one is much more integrated. The developer and potential tenants, again, they filed an administrative complaint against the city alleging discrimination based on race and affordability, that the rezoning denial amounted to discrimination based on race and affordability. And the city said, whoa, we didn't even know that this was going to be affordable housing. And the Human Relations Commission in North Carolina affirmed that defense. They found, based on the record, that this developer hadn't really mentioned to any of the decision makers that this development was going to actually serve people at 80% of AMI or below, which I think is really interesting. And I don't know the developer or the facts intimately of this, but I imagine maybe he was trying to kind of slide under the radar, right? He didn't want to draw attention to the fact that it was going to be affordable housing. And that eventually, led to losing of that case. So that case was dismissed with a no reasonable grounds finding. So Joe, do you want me to talk about these other two? They're, municipal discrimination, but not based on affordability, more other protected classes.
Sure. I mean, I think to add that context, just to fill it out, and one of the things that we'll do, because I know you have, I think, more information on these cases. When we post this on the website, we can provide that information so people could look at it. Because such as the city of Wilson, I'm putting my planner's hat on. Did they deny it because of impact to roads or the surrounding community? And there is, regardless of whether something's bringing in affordable housing or not, you're always going to have that tension of making a land use change in an area and people just not wanting to see things change regardless.
Right. But to your earlier point, if you got a good comp plan and you're faithful to it and it accurately reflects the true affordable housing needs of the community, those are all going to be good, legitimate, non-discriminatory reasons to make decisions. Well, I'll briefly touch on New York and Arizona, because these are pretty big cases in the fair housing world. So the Village of Garden City in New York, this one was interesting because the locality hired a consultant to recommend a rezoning for a particular area. And the consultant said, yeah, you should do, and I forget what the classification was, but it was going to permit 311 multifamily rental units by right in this particular, on these parcels. Significant community opposition emerged, and the village basically backtracked and they rejected their own consultant's proposal and amended it to allow only 36 multifamily rental units and by special permit only. So that's a pretty big difference, and I think a pretty good reason for the developer who was interested in building affordable housing here to take a closer look. So they ran the numbers, and these are, again, these cases are complicated in ways that I mentioned before, but also because they require a lot of demographic analysis, right? Statistical analysis. I mean, many of these cases require expert witnesses to come in and crunch the numbers. But here they found that basically this rezoning change disproportionately negatively impacted people of color and perpetuated segregation in the village. Also, important circumstantial facts: there was zero affordable housing in the village at the time. I don't know at what percent AMI, but glaring lack of affordable housing opportunities. And there was a long history of opposition to affordable housing proposals in the village. So the developer sued the village of Garden City and won pretty big. So this is the court ended up awarding a bunch of really, I don't know, significant relief. So they issued an injunction to say you can't discriminate. They made all the Garden City officials, the village officials, get fair housing training. They made the village hire a fair housing compliance officer. And the court required expenditure of reasonable sums to fund the relief requested by the judgment. So the court said, serious about this. Like you got to take fair housing seriously, and you got to rezone this property. It's settled after 14 years of litigation for over $5 million.
Wow.
And there was court oversight that whole time. I want to read, when we're talking about, I mentioned coded language before and having to prove intent. I want to read one paragraph from one of the court opinions so you can hear how judges are thinking about and analyzing these types of cases. So in deciding whether discrimination had occurred here, the litigants and the judge were obviously looking at the records. They were looking at, what was said in the commission and the elected meetings, what was written, who said what and when and how. And the court says, quote, the tenor of the discussion at public hearings and in the flyers circulated throughout the community showed that citizen opposition, though not overtly race-based, was directed at a potential influx of poor minority residents. Indeed, the description of the Garden City public hearing is eerily reminiscent of a scene described by a different court in a different case, Yonkers, where that court said, at the meeting, the predominantly white audience overflowed the room. The discussion was emotionally charged with frequent references to the effect that subsidized housing would have on the character of the neighborhood. The final speaker from the audience stated that the Bronx had been ruined when blacks moved there and that he supported the condominium proposal because he did not want the same thing to happen in Yonkers.
Wow.
So you see judges, realizing that discrimination does not have to be overt, and you don't have to have direct evidence to show that a decision was really motivated by discriminatory intent. In the city of Yuma, Arizona, that's another case that went on for more than 10 years. It ended up settling for $2.8 million, and the city had to pay their own attorneys and costs and fees. I mean, that's really expensive. This was actually a developer known for developing Hispanic neighborhoods, I guess housing in neighborhoods where Latino folks live. They wanted rezoning to decrease the lot size to build single family homes. So they wanted to do 198 units instead of 145 units by reducing the minimum lot size from 8,000 to 6,000 square feet. The city staff and the planning experts both recommended approval of that request. Public opposition emerged, including folks making comments on the record like, quote, according to the DOJ, the U.S. Department of Justice, households with incomes of less than $75,000 account for 91% of all crimes nationally, as well as 91% of all rape, murder, assault, armed robbery, etc. The types of lots and houses that this developer is considering will be catering to this group of people. What will this cost the city and county of Yuma to patrol this area, and how many innocent victims will fall victim to a predator in this 91% demographic? So here you have the code words about crime. And that's a frequent one. Crime, drug use, prostitution. We don't want these people's kids going to school with our kids. You see, you don't have to say we don't want a particular protected class. It sort of comes through. And then again, with the Virginia law, you don't even have to connect the dots to race. You just have to prove that the decision was based on the affordability, right? That it was going to be affordable housing to 80% and below. So even though everyone at the city staff had recommended rezoning, after the objections from surrounding landowners, the council denied the application. Here's a really important fact in this case. The developer's rezoning request was the only one that had been rejected out of 76 applications in the preceding 3 years. So that too tends to indicate something shady might be going on here.
Well, and it sounds like, typically rezonings are for greater density. And so it sounds like it's pretty straightforward. This was for a greater density,
Right.
regardless of all other factors.
Exactly. So those are a handful of cases, and it remains to be seen which ones will come in Virginia, but I think those are instructive as we predict some of those. So I want to make a really important point that our law has an exemption for the affordable housing paragraph of discrimination. And this is directly out of the statute. So remember, I showed you the law earlier. It says a locality can't discriminate against in land use decisions because the housing development, the proposed housing development, will serve people at 80% of AMI or below. Then there's this exemption. However, a locality can discriminate, right? They're exempt from that. They're not liable for that discrimination if they can show that the reason that they did not want affordable housing in that particular area is because they were considering or they wanted to limit high concentrations of affordable housing. Full stop. And Joe, before you ask me, I don't know what affordable housing means here. I don't know if that 80% attaches here. I don't know what a concentration is. I don't know what a high concentration is. And I don't know what considerations are. But this was meant to solve a couple of legislators' concerns. They represent jurisdictions that they feel already have more than their fair share of affordable housing. And they don't want developers of affordable housing to basically be able to force their way into those neighborhoods and concentrate affordable housing. They want the affordable housing more spread out. So that's why you see this language in the law.
Yeah, it is interesting. And it's, thinking, going back to the comprehensive plan, I think that's part of the work of a locality when they start to survey, what are the typical incomes in certain neighborhoods and how do you integrate it? And it's a longstanding problem. How do you integrate, relative incomes within a community to address all sorts of needs, infrastructure, schools, roads, so that it is, I think, more equitably distributed throughout a community?
Yeah, I mean, that's the $1 million question, why I'm not a planner. That's a big task, but it's a really, really important one. And it's been a problem in this country from the get. And you saw in this, in the 60s, legislators trying to tackle some of those problems through a fair housing lens. So to the extent your members and county officials are even aware of this and they're thinking about fair housing and they're thinking through the lens of housing equity, right, and integration on not only race but income, that's half the battle.
Mm-hmm.
So what happens when someone wants to bring one of these cases? Just a few notes on sort of the procedures of how these play out. So these cases are special in that I mentioned the Virginia Fair Housing Office earlier. Anyone who feels like they've been discriminated against in Virginia in any housing context based on any protected class can file a housing discrimination complaint with the Fair Housing Office for free. And if it meets certain elements, it will get investigated. But these cases, including other zoning land use cases, if someone files one of these at the Virginia Fair Housing Office, the law requires them to immediately refer those cases to our office. The thought being that these are maybe more complicated or broader impact. They involve, various constitutional issues, separation of powers issues. So I'm going to see these cases sooner than I would, just another type of like a refusal to rent based on race case. And then we're going to do our own investigation. If we believe discrimination may have occurred, we're going to go to state court. And if we can prove that discrimination happened, the remedies and the relief that are available under the fair housing law are very broad, broader than a lot of different laws. And one of the reasons why I really admire the fair housing law is because I think it's a very powerful tool to prevent and end discrimination. So these are the types of things that a court could award. Injunctions, right? They can make a locality do or not do something. Pretty big civil penalties. Making the defendant or the locality in these cases pay the attorney's fees of the other side. And then obviously we're also talking about monetary damages, compensatory damages, and punitive damages. And compensatory damages in these cases can be significant because that would be the out of pockets that the developer sunk into making the rezoning request, right? And that if they were denied based on discrimination, that they have to be made whole for that. So I don't mean this to be scary. I just mean this to help folks understand that if liability is proven, the remedies can be pretty big. So Joe, I'm going to rely heavily on you for this slide, but here are some what I consider best practices to avoid these cases in the first place and to really prevent the discrimination from happening so you don't have to deal with litigation on the back end. And again, I'm not a planner, I'm not a local elected. Y'all know this better than I do, but here are some, I think, principles that are best practices when you're trying to avoid discriminating against affordable housing. Educate the community on the need for affordable housing and educate yourselves on the need for affordable housing. I'll end the next slide with resources. There are 1,000,001 resources on the need for affordable housing. Trust me, we need it. Everyone needs it. And just reframing how we talk about affordable housing. You notice that I tried not to use the term NIMBY in this presentation, even though we called this bill the anti-NIMBY bill throughout session. I think how we talk about affordable housing and people who are worried about affordable housing is really important to getting more affordable housing built. So housing is infrastructure. Affordable housing provides opportunities for everyone. You know, I will share that I grew up renting apartments, affordable apartments, you know, that were in certain communities because my family couldn't afford to buy. So I grew up being a renter, and there's stereotypes about renters, or especially renters of moderate income. And, you know, we didn't commit crimes against our neighbors. We didn't tear up our properties. I think we should all be thinking about all of us who need an affordable place to call home and talking about it in those terms. Another great stride made by the home builders was this new code section. This was from the 2020 General Assembly session. It sets out in the state law a detailed sort of framework for localities to adopt their own inclusionary zoning ordinances that help further and reduce barriers to the creation of affordable housing. Address legitimate opposition. I don't mean to say that everyone that's opposed to affordable housing is doing that because they're discriminating. There are some legitimate concerns, and that's really what I think localities should be focused on. Make sure when folks do show up and say stereotypical, demeaning things about folks that live in affordable housing, that you as a decision maker you're not taking that into account when you are making your decision, and don't use that opposition to make it harder for the proposal to pass, right? Don't impose discriminatory conditions on the development to basically make it go away or make it too expensive to eventually be built. I know this is a big trend across the country. I'm not sure where we are in Virginia on it, but basically the more by right development you can allow and the more approvals for multifamily, for density, for affordable housing you can have staff do rather than a public hearing, you reduce the chance for some of this opposition that really creates the sort of the background for this litigation. And then there are so many amazing affordable housing developers and advocates in Virginia, and they are great partners. So I encourage folks to get with them early, understand their needs, understand what they can bring to the table. They're great at dispelling myths about affordable housing, and they're good folks that, you know, sort of have on speed dial on one of these proposals before your locality.
I think all of this is really great. For people watching this webinar, VACo is involved with the Department of Housing and Community Development and Virginia Housing, formerly VHDA, on a study that's going to the General Assembly this year, looking at housing, affordable housing in general across the state, and trying to address some of these issues, with recommendations. And it's been great to, talk and collaborate with, those building affordable housing, those that are advocates for affordable housing, and kind of learning where we can meet on some of these things. The increased by right development is really kind of a tricky one, particularly say in Northern Virginia, because you could maybe generally upzone an area. It increases the value of the land, but does it increase it for affordable housing? And that's a good question. How do you build that in? I think it all goes back to the comprehensive plan. How do you make that fit? On the inclusionary zoning ordinance, we had an interesting conversation with blanking on our delegate's name from Charlottesville.
Hudson?
Sally Hudson, thank you. She spoke at our legislative day, and she really put it to us. She's like, tell us what you need, localities, in enabling authority in state code. Tell us what you need, and we could put it in there. I know she's been a big proponent of probably even opening up that inclusionary zoning ordinance and making it even more, I think, flexible for a locality. And she gives some great examples of, and going back to the AMI, what does 80% AMI mean in Charlottesville versus Northern Virginia, and how you can really tailor a program at a local level. So I think those are some of the things that hopefully we can start working on. I also know that JLARC, the Joint Legislative Audit Review Commission, is looking, they're doing a study right now that is going to look specifically at zoning and affordable housing. And so I think we're going to be interested in seeing where that comes out.
Me too, and I don't envy all of you who have to do these big math heavy studies and then come up with real solutions, some of which are politically hard, some of which are expensive, but I think all of which we really need. It's easy for me to sit here and say, just don't discriminate. And that's a lot easier than folks like you who have to come up with full, policy menus for localities. But I do agree and want to emphasize, and I should have been better about threading this throughout my presentation, each locality has their own specific needs. And this law does not seek to undo local knowledge and local analysis of what folks in those communities need. This is not trying to make everyone the same. This is just trying to take stereotypes about who lives in affordable housing out of the decision-making context, whether implicit or explicit. So I hope counties and your members will see this as a tool, one of the tools that they can use, along with all the other ones that you're talking about are being developed around the state to finally get some affordable housing on the ground in Virginia. So Joe, this is my last slide. This is not homework. These are just some references. I think it's important to have handy a study for folks who are numbers people to show, and there are a million of them, but here's one from Trulia. If low-income housing, low to moderate income housing comes into a neighborhood, it does not lower the property values. It just doesn't. That's a myth. It's been busted many times. The second one here is, again, the importance of affordability. Like, all of us need an affordable place to call home. We're talking about a lot of us who have housing burdens, and that's not a good way to live, and you're not going to thrive as a family if you can't afford somewhere to live near a decent job. The National Low Income Housing Coalition and Housing Forward Virginia and the Partnership for Housing Affordability are three nonprofit groups. National, state, and local levels are the last three bullet points there. And these are really good practical resources about overcoming so-called NIMBY in localities. And some of these actually speak specifically to local electeds and to county planning staff and other staff about how to really address some of these concerns and still do the right thing, follow fair housing law, and create affordable housing.
Well, this is great, Helen. We're going to provide those resources on the webpage for this webinar. I'll conclude with a couple thoughts and maybe a discussion. And I appreciate what you were saying earlier about trying to not necessarily always bring in the NIMBY, because I think sometimes that phrase gets thrown out, and it could be meant to kind of disqualify a person's point of view before you actually hear it. And so I think it's important for all of us to understand, whatever context you're in, that, as I think in a previous slide, is addressing legitimate concerns is what you're really seeking to do, to hear. What are your thoughts on what's going on at the national level and through the Biden administration and all the resources that are coming through the Rescue Act, potentially through legislation on infrastructure, things such as broadband, but housing is a part of that, a big part of that. Do you see a lot of resources funneling down to the state and the local level, and how we could use those to address affordable housing?
Yeah, I will admit, I haven't sat down and read those stacks and stacks of federal bills, although I do understand that there's a big pot of money that's going to be made available to localities to incentivize some comprehensive rezoning to allow more inclusive and affordable housing to come in. And I think that's a great incentive, right? Money.
Yeah.
I mean, to me, it feels a lot like the affirmatively furthering fair housing path, which again has been in the law since the beginning. It says, in recognition of what Senator Mondale was talking about, right? We're creating segregated communities, which was leading to disinvestment in Black communities and extra investment in white communities. And that was creating really scary situations. And it was creating community unrest and violence and disenfranchisement and a whole bunch of things in the 60s, y'all. And so the law said, hey, federal government, you have to spend your housing dollars in ways that consider the effect of the expense, right? If we're going to spend this money, is that going to perpetuate segregation, or is that going to start to solve this problem? And really use the dollars and the investments to drive those policy outcomes. And that part of the law also then, was interpreted to mean local governments. If you're going to take this federal housing money, you have to do the same at the local and the state level. You have to consider the fair housing implications of your investments with this money. And that just wasn't really enforced. And there was like a kind of a weird, clunky way to determine if localities were meeting their duty to affirmatively further fair housing. And that rule was basically suspended under the last administration and is now going to be revived. But I think it's even better to just, hey, we're going to give you this pot of money if you're willing to rezone this way, rezone this area in a way that you can build more affordable housing. That's to me more of a direct way of really drilling down to the problem of some of the zoning realities, current realities that are at the sort of core of some of these issues.
Great. All right. Well, it's funny. I had a set of questions that I really already got to through just the give and take, and you've actually provided kind of in these last slides some of the follow-up. So I don't have anything else to add. I just want to thank you for your time today, for your expertise and the resources that you're providing, and just the education. And as this law becomes effective July 1st, we'll see what happens, and hopefully. As we kind of see, VACo sees it, it's really a state and local relationship, right? So how do we address these issues and make sure that we're all meeting the intent that the legislature passed?
Well, Joe, I will just thank you again for having me, and thank you specifically for your leadership on these issues. It's always a pleasure to see you down at the General Assembly doing a great job for your client and in caring about and housing issues, which means a lot to me. So thanks to VACo and to you for having me, and y'all know where to find me if you need me.
Great. Thanks, Helen.